Many of us wonder what is the real impact of the Mediation Act on other laws in India that refer to mediation. The Mediation Act, perhaps most obviously, consolidates the law on mediation in India into one central statute. 3 points. First, the Mediation Act overrides, with certain exceptions of course, subsumes and amends other laws. The Mediation Act will have an overriding effect for conduct of mediation, notwithstanding anything inconsistent in any other law except some laws listed in the second schedule. The Act goes on to amend several statutes. The Indian Contract Act 1872, for example. We all know that Section 28 of the Contract Act makes agreements in restraint of legal proceedings void. Through this amendment, mediation is now included along with arbitration as an exception to Section 28. The result being an agreement to mediate is no longer void for the reason that it restrains legal proceedings. There are also amendments to the Code of Civil Procedure, notably Section 89, the Civil Services Authorities Act 1987, the Companies Act 2013, the Commercial Codes Act 2015, and many other statutes. The biggest amendment, of course, happens to the Arbitration and Conciliation Act 1996. The part which deals with conciliation in the Arbitration Act, Part 3, is fully subsumed by the Mediation Act. The reason for this partly lies in the definition of mediation. That brings us to the definition of mediation. Mediation is defined by the Act as a process whereby the parties attempt to reach an amicable settlement of their disputes with the assistance of a third person. And that third person is called a mediator, and he is simply a facilitator with no authority to impose a settlement upon the parties. So, there are two aspects of a mediation here. The mediating parties, the disputing parties, attempting to reach an amicable settlement, and a third person facilitating such settlement, but with no authority to impose such a settlement on the parties. The term mediation is defined to include various types of mediation: pre-litigation mediation, online mediation, community mediation, and importantly, conciliation. By effectively stating that mediation and conciliation are interchangeable terms, the Mediation Act finally puts an end to the artificial disconnect forged and precipitated in India through legislation, court decisions, and commentaries. Now we are back in line with the global practice of using mediation and conciliation as interchangeable terms. The third point I wish to make on this is that Mediation Act introduces and explains various types of mediation. For example, international mediation is defined to include a commercial element and a foreign element. A mediation is international where it is related to a commercial dispute and where at least one of the parties is a foreign national or resident or have its place of business outside India or is a foreign government. The domestic mediation, however, is not defined. It is safe to assume, however, that it is a mediation under the Act, which is not international. Online mediation, a format of mediation that took off big time during COVID times, is defined as a mediation conducted electronically or through computer networks. Now, community mediation is a new creature, a mediation to settle disputes that are likely to affect peace, harmony, and tranquility among the residents of any locality. So, in summary, we saw that the Mediation Act consolidates the law of mediation in India by overriding, subsuming, and amending various statutes, and it defines mediation and explains various types of mediation. Do take note that the Mediation Act extends to the whole of India and applies to mediations conducted in India, both domestic and international. It does not, however, apply to mediations conducted outside India and to those commenced before the commencement of the Act.